Okay. Hello, everyone. I'm Melissa Hollick. I'm one of the business mentors with SCORE Fairfield County, and I want to welcome you to this live webinar on Trademark for Creatives. We are doing our fourth webinar in the Creative Series, and the others in this series can be found on demand on our Fairfield County SCORE website. I'm Melissa Hollick. As I said, I'm a business mentor with SCORE Fairfield County, and I'll be your host today. Our presenter is Cliff Ennico, and I'll be introducing him and giving you a little more information about him in a few minutes. So first, this presentation was originally designed to be a live workshop held at the Wilton Library. And so we have Michael Bellicosa, who is from the Wilton Library on. Not sure if he's going to be able to speak. I think he was having some technical difficulties, but just pause for a moment and see if Michael wants to say anything. Okay, so hopefully we'll be able to return to live webinars or live workshops at the Wilton Library soon. So some brief information on SCORE Fairfield County for those of you who may not be familiar with us. We are part of the SBA, the Small Business Association. There are 320 SCORE offices nationwide and over 11,000 volunteers. SCORE Fairfield County has about 130 mentors, and we have a wide variety of expertise in different industries, processes, subject matter expertise in finance, marketing, manufacturing, all kinds of areas. What we do is we offer three primary types of services. First is the free one-on-one mentoring that hopefully some of you have participated in. Can be done via phone or teleconference or email or eventually back in person. To request a mentor, you can go to our website, fairfieldcountyscore.org, and request a mentor via a link on the screen. If you already have a mentor, then please feel free to reach out to them, particularly now, as you probably need some additional support. We have our educational workshops and webinars. Right now we're doing all webinars. We typically do about 150 events a year, educational events. And we also have extensive resources on our website that you can take a look at. We have on-demand webinars. We have templates for business plans, financial projections, etc. Tons of information out there, so I encourage you to take a look at that. Next week, we have 4 webinars planned, including 2 on a new series we're doing called Business Restart. Monday, 5/18, we have one on restarting your digital marketing efforts. And on Friday, 5/22, we have one on finding funding for your business post-COVID. So check out our calendar on our website. We're also sending out emails about these new webinars as we're adding new ones on a frequent basis. So just some useful information about today's event. If you have a question during the presentation, please use the chat window in Zoom. It's on the lower part of your screen, and we'll be monitoring the questions during the talk. We'll be recording this webinar. We are recording it already. We'll end at 1 o'clock sharp to respect your time, and the link to the webinar will be available on our website in a few days' time. So now, some information about our speaker, Cliff Ennico. Cliff is a nationally recognized authority on legal issues and small business and is best known as the former host of Money Hunt, the PBS television series. His weekly business advice column appears in dozens of newspapers and websites throughout North America. He is a frequent contributor to Entrepreneur Magazine and other small business magazines, has hosted over 100 videos on YouTube, and is the author of 16 books on small business and career management. We're very honored to have Cliff. He's always a popular speaker, and so I'll now turn it over to Cliff Ennico.
Hey, thanks, Melissa, very much, and welcome to everybody. Thank you very much for taking some time out of your busy quarantining, your online education, your workouts, whatever it is you're doing to stay sane these days, to listen to a lawyer yammer on about a topic that may or may not be of interest to some of you. First of all, as Melissa mentioned, this is a program that was originally sponsored by the Wilton Library. And since Michael had some technical problems, I just want to say a couple of nice things about the Wilton Library, if I may, in Wilton, Connecticut, which is just north of Norwalk, for those of you who are outside the area. We all like to think that libraries are just about books, number one, and number two, that all libraries are the same, that they all do the same stuff. Those are two very bad prejudices that we all have when it comes to libraries, and they're no longer true, and they haven't been true in some time. Even if you are not a resident of Wilton, Connecticut, you should definitely consider checking out the Wilton Library and all the wonderful things they have to offer. Whenever I am in Wilton visiting a client, I always make it a point to stop by the law library. There's always some wonderful things going on. I am a used book sale fanatic in my personal life. It's one of my hobbies, and they always have some amazing stuff. I never leave there empty-handed when I'm there. They've got some wonderful programs. Search online for Wilton, Connecticut Library, and I'm sure you'll get to their website, and they just got some wonderful, wonderful things. And you and I may actually meet. Just make sure that we don't fight over a used Stephen King or something like that. Make sure we don't get into a cat fight in the lobby. That's always a dangerous thing with me. Anyway, I'm a lawyer and I will win. All right. So moving on with our program today, as Melissa said, this is the fourth in a series of four. The first three programs, the first program dealt with just a basic overview of business for artists. Successful artists do not have to starve in order to be great artists. That's one of the great myths of all time. And we tried to debunk that. The second program was about marketing. My good friend Randy Spina, who was a leading small business marketing expert, gave just an absolutely wonderful program on the ways that artists, especially she herself is a creative artist, she does web design and stuff like that. So she's talking a lot about that in that program. And then last week I did a program on copyright for an entire hour. These programs are all available on the SCORE website archive. If you go to search for Fairfield County SCORE, SCORE, you'll find their website. Click on the programs link and you'll see there's a section there called archive. All three of these programs are in archive. And so we may get into a little copyright stuff in today's program, but in case we don't answer specific copyright questions that you may have, go and look at the program that we did last week on archive. It's absolutely free, and I guarantee we'll be able to answer any questions you have. So if you didn't believe I was a lawyer now, you believe it now. These are disclaimers. We lawyers always like to tell you what we're not going to do before we do anything for you. The most important one here is the second one, and we do this in all my presentations. I am a lawyer. We will be talking about some legal and tax stuff today. Trademark is a legal concept, and we're going to talk a lot about legal stuff, but there's a very big difference between giving out legal information and giving out legal advice. There's a very big difference between saying, well, here's generally what the law is all about, which is what we're doing today, and okay, bud, here's what you should do, and Joe, here's why you should do something different. That's advice, okay? That's one-on-one advice. It can only be given, but frankly, I don't know any of you well enough to be able to give you one-on-one advice. I will certainly try to answer basic questions that you have, but if you really need me to tell you specifically whether your logo or your company name is trademarkable, that is something where we would have to develop a lawyer-client relationship, and quite frankly, you're going to have to give me some money. So if you hear anything on this program that sounds like a great idea and you do it and it turns out to be a disaster, you end up getting sued for trademark infringement, you have to file bankruptcy, your spouse divorces you, your kids don't want to talk to you anymore, you lose your house, you're living in a diaper box under the Brooklyn Bridge, you can't sue anybody. That's what this disclaimer basically means. Speaking about bankruptcy, by the way, we are going to be doing a program here on May the 26th. I believe that is a Tuesday from 12 noon to 1 p.m. East Coast time on the new bankruptcy law. You may be aware that in February, Congress amended the bankruptcy code to create a special new bankruptcy law for small businesses. I tend to suspect that with the coronavirus pandemic and the related government shutdowns, a lot of small businesses are going to be sadly interested in this new law. So we're going to be doing an hour on that. That is Tuesday, May the 26th from 12 to 1. I will be hosting that program and talking about the new bankruptcy law for small business. Is it right for you? So pardon the free ad. So let's begin with some trademark basics. Okay. when you start a business for the first time, naming your business is one of the biggest challenges that you have. It used to be easy to name a business. It used to be that, you know, if you wanted to name, let's say you had a small antique store, for example, and you wanted to name it, you could simply, what you did was you took a vacation. You drove up into New Hampshire, Maine, you know, Vermont, some other state. You found a cute little antique store with the name Flibberty Gibbet Antiques, and you said, oh, that's the name I want. You went back home, you called yourself Flibberty Gibbet Antiques, and nobody said anything about it. Nobody cared. But then back in the 90s, this thing called the internet came along, and it changed everything in a big way. Now that little antique store in Vermont that only was serving a local market is now FlibbertyGibbetAntiques.com, and they're selling things to people in 91 countries. They have probably registered their name as a trademark, and they're going to come after you like the hammers of hell with lawyers if you try to steal their name. It's very hard now to name a business. Here are the questions you need to ask when you're looking to name a business. Number one, is it memorable? Does it stick in people's heads? You know, Flibberty Gibbet Antiques, sorry, I said that very fast. How do you spell it? If you're looking to search for online, how do you spell Flibberty Gibbet? How do you spell my last name, for example? I mean, unless, if you didn't see that little copyright notice up there, you probably wouldn't know how to spell my name correctly the first time. Is it memorable? Will it stick in people's heads? Can you get, that's the most important thing, really. Your name is one of your best marketing tools, and it should be. Randy Spina would agree with me on that. Can you get a registered trademark? Not all things are trademarkable. Okay, in the very first, but it is an important question. We talked about this in the very first program. If you are looking to build a brand based on your company name, your business name, you have to have a registered trademark. Brand equals registered trademark. Whenever a client calls me and says, hey, Cliff, I'm looking to build a brand, my first question is, have you registered your trademark with the Federal Patent and Trademark Office? That's the first thing you got to do. If you can't get a trademark for your name, you will have a tough time building a recognizable brand. Can you get the website URL, preferably the .com for your trademark name? You know, if you have a beautiful trademark name, but somebody else has the .com name for that, you may have to, you know, threaten them with a lawsuit and get them to assign the URL over to you. There's a procedure for doing that. You know, if you want to use that name. Is the company name available in Connecticut or New York or whatever state you are in? If you have an LLC or corporation, you will have to register that with the Secretary of State's office in your state capital. If you are just a sole proprietor, you might have to file a DBA certificate, a doing business as certificate with your trade name in the county clerk's office or town clerk's office. Last but not least, is somebody else using the name for a similar business? If I go out as Flibberty Gibbet Antiques and there's 50 other Flibberty Gibbet Antiques out there, I do a quick internet search and I find all these people, that's going to be a tough thing for me to do, to deal with. There's just too many people out there. So let's talk about a trademark now. A name is not a trademark. A trademark is something else. Okay. Okay. First of all, what is a trademark? Well, when you trademark something, you do not own it. A lot of people think, oh, if I have a trademark, that means I own the name. No, it's not. It has nothing to do with ownership or with property law. What trademark is a legal monopoly. Now, if you know anything about our legal system, we do not like monopolies in the United States. You know, if companies get too big and get too powerful, they can basically charge whatever they want for their products and services, and nobody can do anything about that. We do not like that in this country. We have a whole body of law called antitrust law that is whose sole mission is to prevent companies and businesses from getting so big and so powerful that they can exercise what we call monopoly power. There are a lot of people who are starting to think that companies like Amazon and Facebook now are starting to reach the point where the antitrust people should be really looking at them a lot more closely than they are today. But we're not going to get into that. But a trademark is a legal monopoly. It's the monopoly that the law gives you. It says that if you have a trademark, if you have registered your trademark properly, and if your trademark application has been approved, only you can sell products or services under that name or that mark. A trademark is not a name. A trademark is a mark. It is something that you put on your products and services to identify them in the stream of commerce, so that if people are looking at a shelf full of products and services that are similar to yours, your product stands out because of the name that is on it. And it can be a name but it doesn't have to be. It can be a symbol. It can be the Pillsbury Doughboy is a registered trademark of, I can't remember which food company. The McDonald's Golden Arches are a trademark. Basically, what it does is it identifies X brand of merchandise, and it can be your name, but it could be something else different. So Xerox Corporation makes a whole lot of different machines, copiers, printers, scanners, and that kind of stuff. But if you look at the box, it doesn't say Xerox Corporation on it. What it says is Xerox Model 6700 or something like that. That is a registered trademark of the Xerox Corporation. And it must be used in commerce. A trademark has to be renewed every 5 years. We'll talk about that in a minute, but it can be lost a lot easier. Unlike a copyright, which attaches when you create a work of art and it lasts basically almost forever, the life of the author plus 90 years or something like that, or 75 years, I think it is now. It's a long time. Trademarks must be used. If you don't use them, you lose them. And we'll talk about that a little bit more too, how it happens. If you are planning on branding your business, you need a registered trademark. That's what a brand means in legalese. Branding without a registered trademark, you're going to have a tough time building a brand for any type of product or service, artistic or otherwise. One little thing, generally, when we talk about trademarks, we're talking about trademarks for products. If you are doing a service, you can sometimes get a registered trademark for a service, but that's called a service mark, an SM, as opposed to a TM. I'm just going to refer to trademarks throughout this program just to keep from driving you all crazy, but just keep in mind there is a difference there. If I were to get a trademark for my law practice, it would be a service mark, not a trademark, because legal practice is a service. Okay, trademarks versus copyrights. You trademark marks used to identify goods and services in commerce, brand names that you are looking to use as an identifier on your products and services, logos. Now, I know we have some people here who are graphic designers who design logos and other graphics for businesses and for clients. I have a whole section of this program toward the end where I'm just going to be talking to you for a few minutes. So just be patient. I know you have a lot of questions, but I have about 5 minutes of stuff that's going to be exactly just for you later on today, because you're the people who live in the trademark world more than other artistic people are going to be. You copyright slogans and marketing copy and graphics other than logos. So for example, Maxwell House Coffee. Maxwell House is a trademark of, I can't remember who owns them now, General Foods or somebody like that. But the slogan, good to the last drop, is copyrighted. It's not trademarked. So think about that. A slogan is copyrighted, but the name is trademarked. The brand name that actually appears on the products is trademarked. Okay. Let's talk about, you do not have to register your trademark with the trademark office, although it is strongly, strongly recommended. Let's say, for example, that your lawyer tells you, you got a good name here, Cliff, but it really just can't be trademarked for one of the reasons we'll talk about a little bit later. You may still decide that you want to use it anyway. Well, geez, nobody else has it, and it really does fit what I do very well. If you've ever seen a name on a product with TM or SM at the end of it, we call this a common law trademark. This is a trademark that has not been registered with the trademark office. Basically, when you put the letters TM or SM next to a name, and you can do this with virtually every name, it basically says, I'm claiming this as a trademark. I don't know if I can register it or not, but I'm claiming it as a trademark anyway, and I will sue you if I see you using this mark for the same or a similar product or service. So let's say you do this, you put your little TM on something, and you find out that somebody else is using the name for the same or a similar product or service. You have your lawyer send them a nasty letter. Well, you can certainly sue for infringement. You can certainly sue the other person, but if the other person can prove that they were using it before you, you lose. It's as simple as that. First to use it is the person who will be allowed to use a common law trademark. Now, it may be the only thing you can get, but it isn't a very strong way to name your products or services. Again, if you're looking to build a brand for whatever it is you're doing, a TM will not be sufficient. Okay, you need for that a registered trademark. This is identified by the R in a circle. It must be registered with the U.S. Trademark Office, which is part of the Patent and Trademark Office. There's the URL. It is a federal crime, punishable with a huge fine and imprisonment if you use the R in a circle for a trademark that has not been registered. Okay, I will repeat this. It is a federal crime to use the R in a circle if you have not gone through the process of registering your trademark with the Federal Trademark Office. Okay, that's very important. You can use the TM or the SM, that's okay, but you cannot use the R in a circle. That is only reserved for federal trademarks. I don't remember what the penalties are, but they're pretty steep. It's like $20,000 per infringement or something like that. It's insane. If you have a registered trademark, you are king. You can sue others for infringement if they are using the same mark for the same or similar products or services. And also, no one else can use www.yourtrademark.com. So if I own the trademark for the word Bionics, which as it turns out I do, you cannot call yourself www.bionics.com or any variation of bionics.com without my permission. If you do, I have the right to send you a nasty letter, and you must, by law, transfer that over to me because you have infringed my trademark. Okay. Now, so wow, this is great. I mean, I want one of these. You know, how do I get it? Well, okay, we'll talk about that in a minute. But there's one more switchable points I want to make. Even if you have a registered trademark, you can still be sued for infringement, and it happens fairly often. You go through the trademark office procedure, they give you the trademark. Next thing you know, you're getting a nasty letter from somebody you never heard of in some godforsaken part of the country saying, you know, cease and desist, you have infringed my trademark. You know, you can still get sued for trademark infringement, and if they can prove, especially if they involve the trademark office, there is a possibility that the trademark office will deregister your trademark because it is infringing. Now, that doesn't happen very often. What usually happens is the person that is suing you is somebody who's using the same trademark, but for a different type of product or service. And the issue is going to be, are people confusing your products with theirs because they're too close? That's what usually happens here. You know, but let's say there was a famous case from the 1990s, McDonald's, the restaurant chain. They went after a little mom and pop restaurant in southern Illinois, as I recall, called McDonald's Family Hamburgers. And it was run by the McDonald's family. They didn't just pick the name out of the blue, and they had been using that name since the 1920s. Long before Ray Kroc, you know, got McDonald's off the boards in the I think it was like in the late 1950s, early 1960s. So the court actually went up to one of the federal appeals court, and the court basically said that that Microsoft could not sue this little restaurant for infringement. They had to allow them to use that trademark in their particular area. As long as they used it for the family restaurant and didn't try to build a nationwide hamburger chain to compete with McDonald's, they were allowed to use that name. One of the few trademark cases in which the little person actually won here. This was back in the 90s sometime. It was out in Illinois. And if you do find, usually when you register a trademark and somebody else comes after you, what you do is in order to stay out of court, what you do is you negotiate what's called a coexistence agreement. That's an agreement where you basically say, okay, as long as we agree that I am doing this and you are doing that, we agree that I'm not infringing. You know, if you get into my area or if I get into yours, then we are infringing, and the agreement spells out very precisely where those boundaries are. You're basically doing legally what the mafia always used to do in the old days. Okay, Louis, listen, we're not going to fight over this. You guys take Brooklyn, we'll take the Bronx. We'll both make money. We'll both do great, you know, selling drugs or whatever the hell we're doing. It's a legal way of doing exactly that kind of thing. Or you'll get a license from the other company to use that trademark, or you'll license them, as long as you stay out of each other's hair. When you register a trademark, you cannot register a trademark for everything. You have to be very specific about the products or services that your trademark is going to be attached to. And if that changes, you have to go back to the trademark office and amend your filing to expand to different uses. And they charge different fees per individual use. It can get very expensive if you're not careful. So for example, let's say, for example, you are, with all the pandemic, toilet paper is sort of a form of currency, I understand now in some parts of the country. You may get the temptation of developing little teeny tiny rolls of toilet paper, and the temptation may strike you to call these Microsoft toilet tissue. Okay, that would be very, very tempting. If it were me, I would be very tempted to do that. If you do that, however, you are going to get a nasty, nasty letter from Mr. Gates' company in Redmond, Washington. Even though you're in a completely different area, even though you are not doing computer software, he is not doing toilet paper, he is still going to come after you because you're kind of making fun of his brand name. There's a word for that. It's called trademark dilution, and he may come after you for that. But just keep in mind that even with a registered trademark, the key is if you're going to get a registered trademark, make sure you or your attorney do a very thorough trademark search to make sure there's nobody else out there that has a prior claim. And I'll tell you some things about that in a few minutes. How long does a trademark last? Well, initially, it's 10 years after registration. This slide is a little bit out of date. It must be renewed every 5 years. They changed the law last year. I apologize for that. It must be renewed every 5 years. You can renew indefinitely, but you lose it if you stop using it in commerce. Okay. If you're not actually using it, if you're not actually selling products or services that have the mark on it, sooner or later you will use it. Other people will be able to use it for similar products and services. If you don't defend it against infringers, if you find out that somebody else is using your name for a similar, you must send them a nasty letter, threatening to sue them if they don't do X, Y, and Z. If you fail to do this, then the law is going to say, well, okay, you got a trademark, but you don't care about it all that much, so we're going to let other people use it. What the hell? If you're not willing to defend it, we sure as hell aren't going to do it. You got to be careful. And this happens very often, you allow it to become generic. You come up with a product or service that is so popular that your name becomes the generic name for that product. A lot of people don't realize this, but escalator, elevator, aspirin, Kleenex, these were all at one time registered trademarks. But let's face it, when you blow your nose into a soft tissue, you are blowing your nose into a Kleenex, even though you are not using the Kleenex brand of paper tissue. But not Google. Google, believe it or not, has fought this in court. They won a federal court judgment in 2014 saying that people cannot use the name Google as a verb as part of their name. Without infringing the Google trademark. Now, let's face it, whenever you or I are searching online, what are we doing? We are Googling something, right? Even though we may not be using Google's Chrome search engine. We're using Firefox or something else. That technically does not constitute infringement as long as we are not making money off of it. But if I were to create a company called supergoogle.com, with all kinds of technology that help you do things on Google faster, the Google people will be coming after me with every power known to God to get me to shut down. So be aware of this. There's actually a case pending in front of the Supreme Court right now. This is spring 2020. There's a case that's going to be decided, I think, in the next week or two. The company, it's a online travel company that calls themselves Booking.com. And they tried to register a trademark for Booking.com, and the trademark office rejected it because they said it was generic. It was descriptive. When people book travel, that's exactly what they're doing. They're using the word to book as a verb. So they denied it. The company has challenged it, and it's going to go all the way to the Supreme Court. What they're saying is, we're not asking for a trademark for the word booking. We're asking for the trademark for Booking.com. No, we don't want anybody else calling themselves Booking.com or BookingTravel.com or any variation of that. It's going to be interesting to see what the Supreme Court says about that. Okay, when we think about trademarks, most trademarks are federal trademarks, but you should be aware most states, including Connecticut and New York, have state trademarks. They're pretty worthless, to be honest with you. I advise my clients not to do them. For the same cost of getting a Connecticut trademark, you can get a federal trademark, and it's much more valuable because it covers the entire United States. A Connecticut state trademark only protects you within the borders of the state of Connecticut, which is not that big a state. Let's be very honest about this. So if you have a little local restaurant or something like that, and you just want to make sure that nobody else in Connecticut calls themselves by the same restaurant name or bar or something like that, maybe a Connecticut trademark is okay. But for the same amount of money, you can get a federal trademark and prevent anyone in the rest of the country from using that name for a bar. I mean, why would you not spend a little bit of extra money and get a federal trademark? Even a federal trademark, though, does not protect you in doing business overseas. What about overseas? Okay, here we are not in the copyright world. Those of you who attended my copyright program last week know there is something called the Berne Convention, as in Bern, Switzerland. It was passed in the in 1890s sometimes, and virtually every country on the world except North Korea, I think, has signed on to this thing, where if you have a copyright in country A, and you know, somebody else in country B tries to steal your copyrighted work, you have the right to sue in the courts of country B and shut them down, even though you haven't registered your copyright in country B. That's basically what the Berne Convention says. Trademark does not work that way, unfortunately. We do not have a global trademark treaty. There are several multinational treaties. If you look at this site that's INTA.org, International Trademark Association, they have a whole site that basically tells you what treaties apply between different countries. Roughly half to 2/3 of the countries in the world are party to a trademark treaty of some kind that would give you some protection there. You know, but they're not as strong. We don't have the kind of strong protections here that we have in the copyright world. You will still have to register, you know, under these treaties, even if let's say you want to, somebody's infringing you in Brazil, and there is a treaty in which that Brazil has signed, but you still have to register with the international authority and identify the particular country in which you want to register your trademark so you can sue for infringement. It's not automatic. You can't just go hire a Brazilian lawyer and off you go. You're going to have to actually register your trademark either in Brazil or with the international authority that governs that particular treaty. And not every country has signed a treaty. It isn't just North Korea. Some fairly civilized places have not signed a trademark treaty with other countries. Okay, so how do you choose a trademarkable name for your brand? Okay, well, there are a number of steps. First of all, you have to ask, is the name trademarkable? Not every name can be trademarked. The name cannot be a generic term. So California Vineyards is not trademarkable. It could be a TM, but it can't be an R with a circle. It can't be merely descriptive. You know, Cliff Ennico's web graphics, you know, probably won't be able to do that. Geographical, Nantucket nectars. If the only modifier of your name, of your product name, is a geographical location, that's not going to work very well. A surname. Joe's Garage. If you have a garage or you're doing anything automotive and your name is Joe, you know, you can be Joe's Garage, but a lot of other people can be Joe's Garage as well. Interestingly enough, somebody does have the trademark for Joe's Garage. It's very interesting. The estate, I only learned this recently, the estate of Frank Zappa, the rock musician, actually owns the trademark for Joe's Garage, but not for automotive or anything to do with cars or anything, or trucks or anything like that. He got it for music albums and music recordings because it was the name of one of his many, like 80 albums that he did during his lifetime. So sometimes you can get a name, but only for a different category. Again, when you file for trademark, you can't file for everything. You can only file for certain categories. And if the category is sufficiently remote so as not to cause confusion, the trademark office will sometimes let you have it. It cannot be immoral or offensive or scandalous. Back in the 1990s, a craft brewery in Michigan decided to release a beer called Bad Frog Beer, and the beer itself wasn't any problem, but the problem was the label. The label showed a cartoon frog sitting on a lily pad with his paw, well, I don't know what you call it, his flipper out there, and his middle finger was extended. Okay, that was the thing. So actually the feds went after him, but the state of Michigan got him first and basically shut them down, you know, for doing an immoral, offensive, or scandalous trademark. And their beer. In fact, the company actually shut down now. They actually went bankrupt sometime in the late 90s. But I will tell you, if you are an eBay fan at all, search the phrase "Bad Frog Beer." A 6-pack of Bad Frog Beer with the offending label. The last time I looked on eBay, it was going for about $2,000 as a collectible. There are people who collect beer-related collectibles, and the Bad Frog beer label is sort of like a holy grail for people who collect beer memorabilia. Anyway, sort of interesting. If your name is deceptive or provides a false connection, so the Microsoft toilet tissue kind of thing kind of falls into that category. Also, the likeness of a living person without their consent, or the likeness of a deceased person if their image is either trademarked or is copyrighted. So for example, there is a wine, if you go to your local wine store, there is a wine called Marilyn Merlot that has a picture of Marilyn Monroe on the label. They have a license from the estate of Marilyn Monroe to use that. You can't just go out and use, the name. If I go to my wine store and I see my photo on a bottle of wine, I will be extremely offended. Although I will share with you, there is a winery in Italy near Venice that has my permission to use not my name, but one of my catchphrases that I use in my YouTube videos. The owner of the winery is a big fan of my YouTube channel, and he actually asked for permission last year to use one of my catchphrases. It's fears and passions, the two reasons why anybody buys anything. And he actually has a wine. It's a red wine. I think it's a Montepulciano that he does. That is called Fears and Passions Montepulciano, and he does that with my approval. For basically, I asked him for a case of wine a year. I didn't charge him a fee. All I want is a case of wine every year. That's my royalty. That's my royalty for the trademark. So things like that can happen. It's really kind of cool. So. Okay, a name may be trademarkable if it is suggestive. So Mustang, this car rides like a free horse that's untamed. Coppertone, what it makes your skin look like if you use enough of it. Arbitrary names, these are my favorites. Monster, what does Monster have to do with looking for jobs online? What does Penguin have to do with books? What does Camel have to do with cigarettes? I mean, do camels eat tobacco? I mean, there's no connection. These are the best names. Fanciful or coined, like Exxon or eBay or Bienix, a collection of letters that doesn't exist in the Oxford English Dictionary. Here's my rule. The less your name has to do with your product or service, the better. The more it has to do with your product or service, it's much more likely to be rejected by the trademark office as being descriptive. Okay, so step number 1 is the name trademarkable. Step number 2, has someone else trademarked the name. The name cannot be trademarked if it is confusingly similar to another registered trademark, and that patent and trademark examiners have extremely broad discretion to make this determination. Do not do this yourself. There is a page on the trademark website where you can do sort of a quick and dirty search. And if Microsoft has the name as a trademark, it'll probably show up, but it's not something you should rely on. The trademark search process is very complicated. We'll talk about it more in a minute. And it's not something you should do yourself. Hire a lawyer to do a thorough trademark search. Do not rely on the trademark office. They call it TEST, Trademark Examination System, something like that. You can do it yourself, but it only as a very preliminary step. If you really are looking to build a nationwide or international brand on a name, hire an attorney to do a trademark search. Don't do it yourself. A trademark attorney will normally charge you between $2,000 and $3,000 here in Southern Connecticut or Westchester County. In New York City, it might be a bit more expensive. Or you have a choice here. You can hire a trademark service. And we'll talk about this in a minute, but there are services. If you go online and you search for file a U.S. trademark, you will see dozens and dozens of hits with companies that will say, file your registered trademark for $100 or something like that. And these aren't all frauds. Some of them are, but not all of them are. The thing about these services that you need to know, number one, they only do a very cursory trademark search. They go online, they do the testing, which takes about 5-10 minutes, and they give you a blessing and you proceed. There may be other people out there, though, that you are infringing who will come roaring out of the woodwork with lawyers when they see your application on file in the trademark register. Also, too, these services will not help you if the trademark office rejects you. They do not make any warranty at all that your name is trademarkable. All they say is for $100, we'll file the paperwork. And if they file the paperwork and the trademark office rejects it, they'll come back to you and say, okay, you've been rejected, now find a lawyer because we can't help you. I mean, what is that worth? I mean, as in so many other areas with the law, you get what you pay for. So what happens if your name can't be trademarked for whatever reason? Well, be a little philosophical here. If you can't get the R with a circle, well, perhaps no one else can either. Maybe nobody can get the name. And if that's the case, you can consider using the common law trademark, the TM or the SM. So Nantucket Nectars, for example, uses the TM, and to my knowledge, they've never had any problem with anybody else, infringing that name. So they get away with it that way. See if anyone else is using the same or a confusingly similar name. Do a really thorough online search and see if there's anybody out there who's actually using the name. And then get a common law trademark and then market the hell out of your name so that no one else will even think, grow so big so that everybody knows, that's a Snapple. No, we can't use that name. That's too close to Snapple or something like that, which by the way is also a TM rather than a registered trademark. Market the hell out of it. Become so big that no one else is going to mess with you, quite frankly. Be prepared to change your name if someone much bigger than you sends you a cease and desist letter. I mean, if you do a common law trademark and somebody else with a little boutique in Utah or something sends you a cease and desist letter, well, I'm not going to necessarily listen to that too much. I'm going to tell them to go pound sand or something like that. And they can't afford a better lawyer than I can afford. So, maybe the two of us can coexist or something like that. But if you get a nasty letter from Microsoft or Google or somebody like that, or Oracle, then you have to sort of roll over and play dead here. You gotta. The good news is, whenever somebody sees that you're infringing or they think that you're infringing, they don't usually go right to court. What they do is they send you a nasty cease and desist letter from their attorneys, so you do have time to deal with it. And if your attorney says it's hopeless, Cliff, do not fight this battle, you'll be able to get out gracefully without actually having to go to court. Or better yet, just find a better name that's trademarkable. Don't think. Okay, let's talk about logos as trademarks. I said I would have a whole section of stuff. If you are a graphic designer, sooner or later, someone's going to ask you to do a logo for them. Well, what is a logo? A logo is a type of trademark that consists of a design. It's not just a word. It's not like Bienix is just a word, my trademark. A logo is a type of trademark that consists of a design that is generally used and placed on its products or printed material related to its services, its packaging. You must use it on your product or packaging for it to be enforceable. Okay, I can't repeat that often enough. If you don't use it, you lose it. The logo may be a design by itself, a design including letters or words, or a design consisting simply of stylized words or letters. So eBay, for example, the trademark is not EBAY. It is EBAY in a certain font with the B capitalized and with all the four primary colors. That's the eBay trademark. It's not just, I wrote a book a number of years ago, the eBay Seller's Tax and Legal Guide. We had to use the word eBay in the title. And what eBay told us was, as long as you're not reproducing the eBay logo the way eBay does, as long as you use the four letters in lowercase type in black font, we don't care about that. What we do care about is we don't want you using our logo exactly the way we use it, because then it implies that we are endorsing this book, which we are not. They were actually very reasonable on that when we did that. Some trademarks consist solely of letters or words, but these would not be considered logos. Logos almost always have a design or a graphic logo. They're a component to them. There are three types. There are font-based. These are words or initials with a distinctive font only, but they're just words. There are illustrative logos. They're graphics that illustrate what a company does. So for example, let's say you're a house painting company and you use a picture of a brush or a guy on a ladder, with a brush. That's, considered an illustrative logo. We have abstract graphic logos. They don't have anything to do with anything. The Nike swoosh, the McDonald's golden arches. And the more abstract the logo, the more likely it will be trademarkable. Okay, so what do you do with your client? Now, let's face it, generally speaking, legally, if you are a designer, it is not your responsibility to determine if the work that you are doing is trademarkable. That is the client's responsibility. Now, that's the law. However, and so if a client does not specifically ask you to check and see that a trademark is going to be, that a logo is going to be trademarkable, if they don't specifically say, hey, Cliff, when you submit anything, make sure we want to trademark this logo, so please do some basic searching and just make sure that we're not going to get into too much legal trouble with this. If they don't do that, you legally do not have the responsibility to determine if something is trademarkable. But let's face it, if you do a design and the client falls in love with it and they think it's gorgeous, they think it's wonderful, and they go to their lawyer and the lawyer says that it's not trademarkable because it's generic, whatever, they're not going to be happy with you, regardless of the fact that it's not your responsibility to do it. You know, you made them fall in love with something that they can't legally use. They're going to blame you because, let's face it, being human, if it's a choice between blaming you or blaming themselves, they're going to blame you. It's human nature. And it's not going to change. Okay, so my recommendation, and I represent a lot of graphic designers, a lot of web designers, is you need to ask up front if that's something that a client wants. And if the client doesn't care, get it in writing as part of your statement of work, as part of your contract with the client. You know, okay, just so you know, I'm not being held accountable for trademarkability. It's a very simple thing to put in English. You know, even if the client doesn't, though, good customer service may dictate that you do a quick and dirty trademark search, if time and budget permit, before recommending a logo design to a client. This is where the Patent and Trademark Office's test system may be usable. But to be honest with you, the test system is rather difficult to use. And I'll explain that on the next slide. My recommendation, here's where those cheap trademark services can come in handy. If you're a trademark design, if you're a logo designer and you're doing a lot of this sort of work, what I might suggest you do is develop a relationship with one of the cheapo trademark filing services, the ones that charge 50 to 100 bucks, and cut a deal with them. Say, you know what, I'm going to be doing logos. I'm going to be doing like 100 logos a year. I just want somebody to do quick and dirty trademark searches just to make sure that Microsoft doesn't own any rights to these things before I recommend them to a client. Will you give me a bulk rate for simple, quick and dirty trademark searches? And see what they tell you. These are usually small mom and pop companies in the Midwest. They probably will agree to do something like that for you on a volume basis, so that you don't end up looking like a fool to your client. If you do decide to do it yourself, and I do have a lot of web design clients that do it themselves, you can. There is a free trademark search algorithm on the trademark website. First of all, you got to go to uspto.gov, not uspto.com. This is uspto.gov. This is the Patent and Trademark Office. If you go to uspto.com, there is a website there, but it has a lot of stuff on there that has nothing to do with, let's just say that it has nothing to do with anything legal. Okay, and we'll just leave it at that, okay? What you want to do is you want to click on Search Trademark Database, and you click on the link for TESS, which is Trademark Electronic Search System. There are two ways to search, okay? You can just, they give you two options. Well, actually, there's three options. There's one is word only. So if your trademark just consists of a word, you can click on word only, type in the word, and it'll tell you everybody that has anything with that word in it. Okay, and sometimes there's a lot of stuff out there. But if you're doing a logo with a graphic element, there are two options. The other two options are what you want to do. The first is word and/or design mark search free form. This is where you use word descriptions. It's a Boolean search for those of you who remember the old days when they used Boolean algebra. So let's say, for example, your logo is a 5-pointed green star. If you're using this search method, you would type in 5-pointed and star and green, and hopefully you'll get everything that has a 5-pointed green star in it. The better way to do it is the third way, which is the word and/or design mark search structure. Now here, you must master the Trademark Office's design search code manual. This is online, it's free, it's part of uspto.gov. Search for it, bookmark it, and you're going to have to memorize it. Basically what it does, it assigns numbers to specific graphics and combinations of graphics. So if you're going to do a 5-pointed green star, you would first go to category 01, which is celestial bodies, natural phenomena, and geographical maps. Division 01 under that, which is stars and comments, and section 03 under that, stars with 5 points, which results in a complete design code of 01.01.03. You type that into the search to the test thing, and hopefully it will show you all the logos that have 5-pointed green stars in them. How many of you here feel comfortable that you can do that right now? Okay, answer is no. You got to practice, you got to get good at it. Trademark lawyers do this as their bread and butter. This is all they do, day in and day out. They have mastered the design search code manual, and that's why you're paying them $2,000 to $3,000 to do a very thorough search so that you don't make any mistakes. Okay, don't get me wrong. There are a lot of things that you can do without lawyers. This is not one of them. Okay, this is something where you really need to get professional help. No matter how hard you try, you will never be able to do a thorough enough search. So basically, my advice to my web clients is do enough so that you avoid obvious clients, and let the client's attorney do the more thorough search and let them sort of sell the client on which logo they should use. Or if the clients are routinely existing, ally yourself with a trademark service. Have them do the quick and dirty searches. Cut a deal where they'll do it for a bulk rate. Sometimes they'll do it for like 10, 20 bucks if you give them enough volume, and bill their fees into your statement of work or proposal document. But remember, and this is my tip, don't tell the client that you did it. Don't tell the client. Hire the service, do the quick and dirty searches so you don't make a fool of yourself, build their fees in as part of the statement of work, but don't tell the client that you did it, because if you do, then they could view that as a legal warranty that the logo is trademarkable. So if they go ahead and file a trademark and they don't hire an attorney to do it, and the trademark office rejects them, they're going to come back screaming at you, hey, Cliff, you told me, you said you did a trademark search. Well, geez Louise, the trademark office tells me there's 50 people out there that have the same name. What's going on here? Are you an idiot or what? Now you have an angry client, you got a problem. So don't ever tell the client that you did it. Do it because it makes you look good. It's less likely that they're going to have a problem, but don't ever make a promise to a client. You are not a lawyer. You cannot make that promise. Giving a legal warranty that something is trademarkable, that's a legal opinion, and only lawyers can do it. So here are tips for creating trademarkable logos. Look at logos of your clients' competitors and stay away from whatever the hell they're doing. That's one easy way to come up with a trademarkable logo. Avoid logos that are merely descriptive, Joe's Garage, unless of course the client doesn't care. If the client just wants a logo for their Yellow Pages ad, they're not going to be doing, interstate advertising or anything like that people will actually see. Maybe they don't care, in which case, you don't have to worry about that. But again, get it in writing, make sure the client says at some point, I make no warranty that a logo is trademarkable. If you want me to do that, that's for you. There's going to be additional fees involved or something like that. Use a disclaimer similar to the one that I use at the beginning of this presentation. Make your designs as abstract as possible. Okay, again, the less your logo looks like something real, the better, the more likely it is to be trademarkable. Avoid trendy looks, okay? Trademarks are designed to stand the test of time. Hopefully your client's products and services will be offered for the next 50 to 100 years, and you want that name to be, the brand to withstand the test of time. And also to be careful about logos, designs that may, people are getting increasingly more sensitive about not offending anyone. The Bad Frog beer example is a pretty bad one, but those of us who are fans of pancake syrup, as I am, and anyone who looks at my photo will know that I have had some very close encounters with pancakes in the course of my career, can think of at least one trademark that is no longer as viable as it used to be because it simply, would offend a lot of people. So try to avoid anything. If you are including a representation of a person in part of a logo, make sure that it's a sufficiently generic depiction that it will not risk offending anyone or creating, any issues in terms of diversity, inclusion, and all that other good stuff. Last but not least, don't use clip art if your client wants to trademark the logo. Clip art is publicly available. If it were software, we would call it open source. Basically, anybody can use it. You cannot trademark a clip art piece. Clip art is public domain stuff. So if your client doesn't care, then clip art's okay. But if your client has specifically told you they want to trademark the logo, don't use a clip art graphic, because his attorney will probably pick up on that. So here are the key takeaway points. Pick a name that is trademarkable, memorable, and domain nameable. That's not a word. Make sure you can get the URL for it. So if FlibbertyGibbet is your name, make sure that FlibbertyGibbet.com is available, and .net, .org, .biz, .info, all the other good ones. But the .com is the best one for search engines. Use your mark in commerce aggressively, whether you register it or not. Hire a lawyer to do a thorough trademark search before you register. If all you're asking them to do is the trademark search, the cost cost will be much less than doing a full-blown registration. They'll probably only charge you maybe $1,000, $1,500 for that, roughly half. The search is really the biggest part of the trademark process. The filing itself doesn't take much time at all. The forms are very easy to fill out. The filing fees are very reasonable. It's a couple of $100. It's the search that is where the attorney really puts his time in. So it's going to be the bulk of the trademark attorney's fee. Do not attempt to register a trademark without professional help. This is not something you can do on your own. There are a lot of other things you can do on your own without lawyers. This is not one of them. And then when designing logos for clients, consider working with a trademark search service so that you don't have to do the trademark, basic preliminary trademark services yourself. Here are some of my best-selling books. The Small Business Survival Guide is just a nice collection of stories of small business clients I've worked with over the years. And then the eBay Sellers Tax and Legal book. If you are selling stuff on eBay or Amazon, this book has become sort of the Bible for people who have those kinds of businesses online. And this is my contact information if you want to get in touch with me. Melissa, why don't we open the floor here and let's see if we have, I think we do have a few questions.
Yep.
And I'll try to answer as many as I can in the next few minutes that we have available.
Okay, so let me, first one is if someone has a website with their company name, which is also their name, is it possible to get someone to cease and desist using that same name, SuzanneSheridan.com?
Okay, now you have a website with your company name on it, which I assume is not Suzanne Sheridan. But there's somebody else that has SuzanneSheridan.com. If you have not registered a trademark for your name, for the category photographers, technically you can't do anything about that. If her name legitimately is Suzanne Sheridan, she didn't just pick the name because she's trying to rip you off. Her real name is Susie Jones. I hate to say it, she got to the URL, to the domain name registry first, is what happens here. You can certainly, though, be SuzanneSheridan.net, .org, .biz, .info. She can't do a thing about it, just like you can't do a thing about it. The only thing that you could do is to try to register your trademark, your name, as a trademark for the category of photography and photographic services. You're not likely to get that approved, however, simply because even a basic trademark search will show that there are 50 other Suzanne Sheridans who are also photographers. The other thing you can do is change your name to something a little bit more exotic, a little bit more out of there. If anybody ever calls, you people are lucky with names like that. I was saddled with the name Clifford Ennico. If you ever, if a kid named Clifford Ennico beat you up in kindergarten and stole your lunch money, it was me. Okay, I can't hide behind this. I can't say, oh, well, that was another Bill Jones or Bill Smith or whatever. I envy people with names like that. Seriously, you might want to consider legally changing your name. Lord knows the musicians and a lot of artists do that. They adopt, names that are a little bit more exotic or whatever for marketing purposes. This is another more legal reason why you might want to consider doing that. Give yourself the name. What is it? Elon Musk just named his kid like an algebraic equation or something like that. I mean, I don't know how the heck you pronounce it. Even look up Elon Musk's child's name. I mean, God, if they can do that, you certainly could. Okay.
Okay. Next question is a couple questions around the cost of renewal.
Right.
Cost for the trademark, not including attorney's fees, just the FTC cost, and then cost.
Okay. Okay, the cost of renewal. Go to the trademark webpage at uspto.gov. The trick, it's hard to answer that question because the trademark fee, if you're doing it yourself, depends on the number of categories that you are registering the mark for. So for example, when I tried to register Bienix for the first time in the early 90s, I tried to do it myself because I knew that there was nobody out there with that name. It was a made-up word. I initially did the calculation. There's actually a fee calculator on the website where, if you punch in the number of categories, it'll tell you exactly. I wanted to register my name for books, all media, television, radio. I was doing a TV show at the time. I wanted to register also for magazines and newspapers because I wanted to do a syndicated column. And I think I tried to register for 6 different categories, and the total cost came to like $5,000 for all of those categories. I had to sort of pick and choose which categories are more important to me right now and which ones am I willing to wait for and hope that nobody else, grabs the name for those other things. So it's a hard question to answer. If you go to the Trademark webpage, they do have a fee calculator. So if you punch in different category names, it'll tell you, how much the fee is and how much you're going to get charged, before you actually have to pay the fee. Now, what are the costs of renewal? I don't remember offhand. They just changed it recently, and I apologize. I should have that at the tip of my tongue, but I do not. But if you go to the uspto.gov, they have the answer. If you don't renew after the 5 years, you lose the trademark. You can still use it. Losing a trademark does not mean you have to stop using it. Losing a trademark means that other people can now use that same mark for the same products and services, and you can't do anything about it anymore. That's what that means. You have a common law trademark now instead of a registered trademark, so other people who want to use the same name have more rights, but you can still continue to use it. Okay.
Okay, I think that's all the questions we have time for today. So Cliff, thank you very much for presenting. It's a ton of great information. As a reminder, the recording of this webinar will be on our website in a couple days, and also take a look at our website for upcoming and on-demand webinars. And also, if you were looking to request a mentor, you can go on our website and click the Request a Mentor button. So on behalf of SCORE, I'd like to thank everyone for attending today, and have a good rest of your day. Thank you.